My name is Matt Woods, and I would once again like to extend my thanks for all of your attention, and I think Dr. Agarwal left, but as well to the conference for this kind invitation. My name is Matt Woods, and as you can see, I've got some pretty big shoes to fill based on what Marty delivered and what Bill delivered a few minutes ago. And for a gentleman of my stature, that's a little bit harder to do. So what we've decided to do is that my colleague, Brian Vogel, and I are going to tag team this presentation. And we're going to change the focus a little bit from what Bill has been talking about and probably a little bit of what you've heard through the majority of the conference. Because I do not practice particularly in the pharmaceutical or biosciences area. Brian does. But one of the issues and passions for me is both electronics and software. So the topic that we're going to cover in the remainder of our time together, and we will move through this relatively quickly to keep the time frame that we've promised to deliver, is going to be avoiding legal traps in developing mobile apps. Now, throughout the course of my time here at the conference, I've noticed that everybody has been tremendously respectful of the speakers. They give them their attention, they listen, they ask questions. But then I notice that when people aren't being watched, when nobody's looking, what do? They pull out this little device and they start doing this. And the reason why they're able to do that, of course, is because of this tremendous explosion of software applications that we now have at our fingertips. If you go online, if you go to the App Store, you will find applications that allow you to have virtual boyfriend or girlfriends. They allow you to have mustaches to add to your face or hair on your head. Lord knows I need that. Or even, in keeping with the pharmaceutical bent of this convention, allows you to self-diagnose based on your symptoms and get recommendations on medicines. So indeed, what has happened is that we have now reached a world where the common phraseology is, whatever you need, there's an app for that. And indeed, our good friends at Apple have made an effort to trademark that phrase. And the numbers verify and corroborate this tremendous explosion. Apple's App Store, for example, has over 700,000 registered apps. Similar for Google Play. Microsoft is following and getting in the game very quickly. And it's reached the point that it's predicted that by 2014, 90% of all corporations will have mobile applications, mobile apps. And the download data corroborates it even further. According to what Apple has posted, since 2008, there have been over 40 billion, that's with a B, billion downloads of apps. In 2012, Google reported 25 million downloads, and the numbers are expanding as we continue to rely upon these devices. And so with this tremendous explosion, a number of questions arise as to how that's going to intersect with the law. And that's what Brian and I are going to accomplish with your indulgence and patience. Very quickly, what is a mobile app? I think we probably all know that. Essentially, the talking point I want to leave you with is that because of the integration of the software of an app, it exposes the developers of apps to a broader range of attacks by wielders of IPR, of intellectual property rights. Perhaps more so than when you had a desktop with standalone discrete software that the ability to interact with the outside world was more limited. And that is in large part of the reason for this potential exposure of the variety of different types of law. All right, so what I would like to do over the course of our presentation is to focus upon the various legal traps that can occur during this journey, beginning when a developer first decides what platform they're going to go to, and then develops the idea, gets it, launches it to market, and to monetization. And the traps that Brian and I will be talking about are not unique to each of those stages, but the takeaway and the message as we go out and talk to our colleagues who may be operating in this area is that Whereas before, developers of software may have thought themselves insulated from a lot of the legal falderall that they can find themselves exposed to. That is not going to be the case with the maturation and evolution of mobile apps. So, legal trap number one. And I'm going to try to move this along quickly, and again, to keep in line with our schedule. Legal trap number one is thinking that developing an app outside the United States somehow insulates a foreign developer from suit within the United States. The first couple, by the way, of traps that I'll be mentioning are more procedural based upon U.S. procedural law. And then Brian and I will move into the substantive areas. All right, so generally U.S. courts will exercise jurisdiction wherever they find that a party has purposely availed themselves of the U.S. market. And the key test for this is called the Zippo test. That is not a mobile app case, I should emphasize. In fact, there has not been a case dealing with mobile apps per se, but generally software issues and websites are dealt with the same, and it's all following the Zippo pattern. I'm going to go real quickly and show this 3 different types of approaches here because it spans a spectrum of activity. The green check mark that you see relates to commercial websites. If an app is essentially doing things to transact actual business, it is more likely than not that you can be pulled into a U.S. court, even if your facility is only in Mumbai or Bangalore or Ottawa, Canada, wherever. On the other end of the spectrum is a passive website. If it's just simply some static information, then a U.S. court is likely not to allow jurisdiction, find jurisdiction, and that's the red X that we see. Where it gets a little bit mixed and a little bit muddied is the notion of interactive websites. If some information is being provided, but then you're pulling some information from the user, and there's an exchange going on at some level, even if it doesn't rise to the transaction of money, the courts can still find that that is going to subject you to jurisdiction of the court. So the Zippo test is something that we have to be very careful of because ultimately you're back to this test of purposeful availment. And that will really come into play if, in fact, the launching of an app is done through something like an Apple App Store or Google Play. Because when you reach that situation where you've now affiliated or partnered with Google or Apple, there's a presumption that has started to arise that you are trying to take advantage of not just the U.S., but the entire world. So that moves us on to the second legal trap, which is assuming that the App Store protects the developer from the lawsuit. For those app developers who decide to put themselves on Google Play or the App Store, Apple's App Store, there may be this sense of they've done their homework, that's really Apple's problem or Google's problem. No, in fact, that is just not the case at all. Because when you enter into that relationship with Apple or Google, they make you sign boilerplate contracts, which essentially they delegate the responsibility for any IPR issues back to the developer. They essentially try to absolve themselves of that. And I'm sorry, you probably can't see that highlighted language. I apologize for that. But it's wonderful legalese for saying it's your problem, not ours. Google Play does the same thing with language that essentially says you're going to represent that any intellectual property problems are that you don't know of any problems, and also ultimately it's your problem if somebody comes after us. What's interesting throughout all this is that both Apple and Google not only point the finger in the direction of the app developer, but then take a step further and say that even if somebody challenges your app, we will reserve the right, as Apple or Google, to take your app off the store. Doesn't matter if there's a judgment, you don't need a trial. All there has to do is be an allegation. And they can revoke, cease distribution, and take the app off the store. Only on the allegation. So the third legal trap that I'd like to offer up here is failing to name the App Store as a party to the suit. And that's what I'm kind of referring to in that last one, because it may very well be that this happens, that an app is launched, a third party says that's violating their IPR, starts a suit against the developer, and Apple or Google or someone takes the app off. Where does that leave you as a developer? Well, essentially the case of Symantec is a good example of this. Symantec was the developer of a language teaching tool, a language teaching app allowed translation between languages, and helped early learning of languages. And they were accused, and Symantec accused SFY of patent infringement, copyright infringement, and trade dress. Within weeks of filing the complaint, Symantec issued an objection notice to Apple saying, wait a second here, SFY is infringing our IPR, and asked them to remove the app. Apple did so, even though SFY denied the allegations. So they denied it, and Apple eventually removed it from the store. So what did SFY try to do? They actually moved the court. They petitioned the court to say, don't let Apple take it off the store. It's going to destroy our business model. And what the court said is, because Apple was not a party to the case, it had no jurisdiction over Apple. And so it refused to reinstate the app. And so SFY had absolute, total pressure on it to capitulate to Symantec at this point. So the app was removed from both Apple and Google Play. The case settled, and then, and only then, was it returned. So the point and the takeaway here is that if you are representing a developer of a mobile app outside of the United States, there is still this wealth of potential that you could find yourself, your business model, significantly disrupted because of the assertion of IPR rights. So now we're going to shift a little bit to actual substantive law that each Brian and I will talk about. This was all about procedure, but we'll cover quickly here trademarks, copyrights, patents, and trade secrets as they apply through some case studies relating to mobile apps. And with that, Brian, if you'd like to take over. Yes, even if it's a free app, although because so, well, that's a whole nother discussion, because revenue models for apps is largely through advertising, even when it's a free app. And so yes, there is still the ability to get an injunction, albeit, and some damages based upon a quantification analysis similar to what Bill was talking about.
The second question was, why would I want to remove an app off the App Store if, for example, the IP regulation was only on US soil and there was no other IP? That's hard on the guy who's developing it, right? I mean, especially when so many of you are trying to bring three things on an App Store and kind of remove off much of the growth that people do.
Absolutely. I think the answer to that question is probably so multifaceted, because people take different attitudes about enforcement and different tipping points in terms of where. But I think if you look at even the Symantec case, SFY wasn't making a lot of money. I think it was a dollar value app. I don't think it was free, but it certainly wasn't generating a ton of cash. So it's a mystery.